I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into number 70 on our compilation list. We will be in 3 different judges' courtrooms. Before I give you the rundown on those judges, just know there will be no commentary and there will be chapters added to these proceedings. Thank you, as always, guys, for joining me, for liking, sharing, comment, and subscribing. The compilation videos have been going crazy. You guys have been loving them, so we will keep them going. Now, let's run down these judges' courtrooms that we're going to be in on today. First, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas, and this is actually a proceeding that happened yesterday. Second, we will be in the courtroom of Judge Donald Chisholm out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Kalo Wilcox out of the state of Washington. Now, I know you guys have been enjoying these compilations. We're going to keep these going for you. And listen, it's about that time, guys. Let's go ahead and jump into number 70.
We will now take up Matthew Schrader on the record now in 2025 TR 1342, State of Kansas versus Matthew Kyle Schrader. Jared Regier for the state. Mr. Schrader, do you appear?
I'm here in pro propria persona, sui juris, appearing specially, not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve 2 charges. Count 1, failed to register a vehicle and classified non-person misdemeanor. Count 2, no proof of insurance, and Class B non-person misdemeanor.
And you said these were allegedly committed when? Which date, according to the document?
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
And location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive my right and present myself.
All right, is anyone making you waive your right to an attorney today by any threats or promises?
No.
Or any other reason?
No.
All right, and you do understand, for the record, that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
All right, I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney. You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count 1. Fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the U.S. mail. If you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
All right. You have filed a written motion for subpoena of what documents from the Butler County
Subpoena
Sheriff?
Ducis Tecum.
Of what?
There are many items on there, and
So you don't know what you've asked them to bring to court?
yeah, I do. I don't have it in front of me, but it's a lot of the typical things like body cam, dash camera footage.
All right. And they have filed a motion or a response to quash at least part of what you requested.
Yeah.
All right. And Destiney, do you have both his motion and the response on the file there in front of you?
I show the subpoena, Your Honor, and then I show the
Motion.
sheriff's office motion to quash.
Okay. All right. Well, we will set those for hearing if necessary, but how do you want to plead on these charges before we get to that?
Well, I feel like it wouldn't be appropriate to plea until I get the evidence and able to be informed enough to make an appropriate plea.
All right. So you're telling me you don't want to plead not guilty today. You don't want to plead anything today. Is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me?
I'm asking you, sir.
How much time I need?
No, I mean how much time the whole hearing you anticipate will be.
20 to 30 minutes.
All right, let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena Ducis Tecum in motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information in this before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
The written response in motion to quash does appear to be filed by Mr. Hulskamp, Your Honor.
All right, let's set a motion hearing on a Wednesday afternoon. Destiney, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but
And you do want it on an afternoon, Your Honor?
yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day.
What are you
November.
looking at? I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Schrader. Do you understand that?
Yep, sounds good to me.
All right, if there's nothing further, let's see.
Your Honor, there are multiple matters still to address.
Go ahead, please.
Your Honor, as given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being set, requested, and this matter is being set over by the defense.
Speedy trial time does count towards the defense, and he is asking for this motion hearing to be set and that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 OR was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by the officers for booking and processing. Your bond will be set at a 3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with deputy in court security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post the 3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
Oh, very well. Look for that invitation on the breakout screen. And Destiney, if you'll put that on there for Mr. Schrader, for the officer in court security 2.
What time? So it's November 12th?
The motions hearing is November 12th at 1:30, correct?
1:30. Okay.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just put the 2 of them in a breakout room.
Mr. Simpson, can you hear me? Mr. Simpson?
I go by Matthew Aaron Simpson. The person that you're speaking on, I don't recognize.
You go by Matthew Simpson, correct?
I go by Matthew Aaron Simpson, but the name that you're speaking of behalf, I don't recognize.
Name that I'm speaking of on behalf of.
Yes, I'm the executor of the illegis.
Oh, you are.
I'm the agent majority. I'm not a minor. I'm competent. And I would like to declare that I, Matthew Aaron Simpson, would like to state on the oath, on the record, that I am declaring a national non-citizen.
Well, your status as a citizen is not really central to these events that bring us here. What brings us here is the fact that you owe money to the court for two different matters, one from 2022, the other from 2024, a total $480. I'm going to recall the warrant for your arrest. How did you come to be arrested?
I don't recognize.
Who brought you to the jail?
I don't recognize.
Your Honor, if I may, I'm appointed this morning for arraignment purposes only, and I know that Mr. Simpson does not wish me to represent him, and obviously that's up to him. But I will let the court know that I did check the inmate screen, and it looks like the 44th District Court is the only matter holding him currently. And he also has a warrant out of Grosse Pointe Farms for a traffic arrest, but this is the only thing in Oakland County, it appears.
Thank you. Well, Mr. Simpson, it really doesn't matter what you recognize or don't recognize, because you're dealing with the power of the government, whether you recognize that government or not. So what we have to do here is figure out how to negotiate a path for you, whether you recognize the power or not. And the fact that you owe this money to the court appears to be the only thing keeping you in jail. It is not the intent of the court to have you be in jail for $480.
I understand that according to
Where do you stay now, sir?
On Earth.
Where do you stay?
On Earth.
On Earth. You have a particular spot on Earth?
No.
Do you have any spot that you have mail sent where you can get mail that's addressed to you?
I don't recognize.
Simpson, you're not making this easy on yourself. You're creating difficulty for yourself.
I don't have a.
Where do you get your mail?
I don't have a place of residence.
Where do you get your mail?
I don't.
Who feeds you?
Who feeds me?
Yeah, who feeds you? When you're not in jail, how do you eat?
I put food in my mouth.
Okay. Where do you get the food?
Earth.
Do you have employment?
I don't recognize.
Does anybody pay you for working for them?
I don't recognize.
Well, you recognize the fact that you're behind bars now, do you not?
I don't recognize.
Reset the show cause. And the bond is $480 cash.
I don't recognize.
You can recognize or not. Doesn't change the fact that you're not going to get out of jail until $480 has been paid on your behalf. Whether you recognize that authority
I
or
got
not, it's happening.
I'm an executor of
You
Matthew.
can be an
Aaron Simpson
executor, you
II.
can be an executor. It doesn't matter. There's $480 needs to be on the table before you
I'm
release.
gonna-
We're done.
I would like to put that into my foreign trust.
You can do whatever you like, sir. Have a good day.
Okay.
So, Mr. Valentine, would you unmute, join us, or I should, if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay, and is that how you'd like me to refer to you?
Yes, ma'am.
Okay, I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, oh, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today. And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted the bond for that amount, and which I believe he was released on October 29th. And within a month, we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh.
I can hear you. I can.
Okay. Yeah, the release conditions that were set were not returned to its original state. The release condition only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were dismissed.
I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything.
We got everything.
For tox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? I'm sorry. American National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. It's my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed. So even my bail, they didn't even lower the bail. I had to argue with the court just to get the bail lowered even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay,
Yes, I have.
so, all right, so you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case. But they're two separate cases now.
All right.
Does that make sense?
Yep, it does. And there was, all right. I guess I don't agree with you. There was a request to October 28th to change release conditions, and that was denied. I guess that was me from the court's docket. That's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing I'm going to set this I'm just going to set everything for that January 14 day. And so that we've got everything together. What time that is, but you either, as I said, 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. But we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending the 3rd degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it under admiralty jurisdiction or common law jurisdiction? No.
Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a common law? Is it under common law or admiralty?
It's under Washington state law.
Don't you have the duty to make the nature and cause clear to me, ma'am?
I have.
Do I not have a right to know the nature of the cause?
Yeah, and I have. And you can put it to writing if you think there's something more. A bill of particulars might be something that would be useful to you to send to the prosecuting attorney's office. But
I
that's
requested
what I've
a
told
bill
you
of
today.
I've requested a bill of particulars, and I've requested the case transcript, and I've gotten neither.
Yeah, it's not going to be transferred. There's nowhere to transfer it. You're in the correct jurisdiction here in
I said
Thurston
a
County
case.
District Court.
I said I asked for a case transcript and a bill of case transcript and a bill of particulars, and I still haven't gotten it.
All right, we'll follow that up with the prosecuting attorney for the bill of particulars, and then the transcript. That would be from the court if you wanted an audio recording of the proceedings. All right,
Still haven't made clear the nature and cause of the charges, ma'am.
All right, well, I think I have. So you're to turn yourself in to Thurston County Corrections no later than tomorrow by 3 p.m. or you can post 10,000 cash or bond. We'll have our next hearing January 14th, 2:30. And you stay clean and sober and law abiding, and you're still on pretrial services supervision if you're out of custody and you comply with them.
So is the prosecution under common law or under admiralty?
We're not going to go in circles here. You have
I'm
an
just asking
obligation
you
to be.
I'm just asking you.
I
As
understand.
my
I've
right. Is it
answered.
not my right to know the nature and cause of the charges?
Yep. I've answered you, Mr. Valentine. I'm not going to go in circles. You're in custody by Friday or post 10,000 cash or bond. We'll see you January 14th. That's all for today.
So why can't we go back to the original release conditions?
I've already made that ruling, sir.
And it was a void ruling. It's a void judgment.
So long, Mr. Valentine. We've talked. Be in custody by Friday or post your 10,000 cash or bond. We're done here.
So you're not going to honor your oath to
We're
uphold
done,
the
Mr.
Constitution?
Valentine. I'm honoring my oath, and I've done exactly what I'm to do by state law and Constitution.
You haven't made clear the nature. You haven't made clear the nature and cause of the charges, ma'am.
Please mute Mr. Valentine. I don't want him to say something that would be untoward for him. So we're done, Mr. Valentine. Turn yourself in by Friday or post your bond.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.